Hey everyone, that's not going to work. Hey everyone, it's me, Leonard French, your favorite copyright attorney, all smiles this morning, and with the perfect hat, because Disney has sued Ron DeSantis after all of the shenaniganery in Florida. The complaint from Disney is really well written. It fills in lots of blanks or gaps. It tells the whole narrative from beginning to end from Disney's perspective. And I think you'll really enjoy it. It's very long, but it builds, and I think you'll really enjoy it. There doesn't seem to be a dull moment in the thing. So without further ado, let's dive in. The complaint was filed yesterday, April 26th, apparently minutes after Ron DeSantis's appointed board of the new Central Florida Tourism Oversight District voided the contracts or agreements that Disney had put in place before. There are some details in here about those agreements, so stay tuned for that. The thing is filed in the United States District Court, Federal District Court for the Northern District of Florida. So this will be a federal district court overseeing the thing, not a Florida state court. And it's Walt Disney Parks and Resorts U.S. Incorporated against Ron DeSantis and members of his Central Florida Tourism Oversight District. We don't normally go over the table of contents, but it is a great way to tell what you're about to read. So they're going to talk about, in their factual background, about the Reedy Creek Improvement District, about the multi-year process that they've been involved in, about Disney's comments on the Don't Say Gay bill, which has now been expanded to K through 12, about Governor DeSantis's and the legislature's disillusion of the Reedy Creek Improvement District, and how that's basically all retaliation, and there'll be a whole bunch of examples of that. They're going to allege a contracts clause violation. Law nerds, how often do you see a contracts clause violation unless you work in that specific field? But this is a constitutional contracts clause violation. We'll get to see that. There's also a takings clause violation in here. I studied takings law in law school. That's always a fun one to talk about. They allege due process violations and First Amendment violations, and then their prayer for relief will be pretty interesting as well. Introduction. For more than half a century, Disney has made an immeasurable impact on Florida and its economy, establishing Central Florida as a top global tourist destination and attracting tens of millions of visitors to the state each year. A targeted campaign of government retaliation orchestrated at every step by Governor DeSantis as punishment for Disney's protected speech now threatens Disney's business operations, jeopardizes its economic future in the region, and violates its constitutional rights. Today's action is the latest strike. At the governor's bidding, the state's oversight board has purported to void publicly noticed and duly agreed development contracts, which had laid the foundation for billions of Disney's investment dollars and thousands of jobs. This government action was patently retaliatory, patently anti-business, and patently unconstitutional. But the governor and his allies have made clear they do not care and will not stop. The governor recently declared that his team would not only void the development agreement just as they did today, but also planned to look at things like taxes on the hotels, tolls on the roads, developing some of the property that the district owns with more amusement parks, and even putting a state prison next to Walt Disney World. Who knows? I just think the possibilities are endless, he said. Disney regrets that it has come to this, but having exhausted efforts to seek a resolution, the company is left with no choice but to file this lawsuit to protect its cast members, guests, and local development partners from a relentless campaign to weaponize government power against Disney in retaliation for expressing a political viewpoint unpopular with certain state officials. Governor DeSantis and his allies paid no mind to the governing structure that facilitated Reedy Creek's successful development until 1 year ago when the government decided to target Disney. There is no room for disagreement about what happened here. Disney expressed its opinion on state legislation and was then punished by the state for doing so. Governor DeSantis announced that Disney's statement had crossed the line, a line evidently separating permissible speech from intolerable speech, and launched a barrage of threats against the company in immediate response. Since then, the governor, the state legislature, and the governor's hand-picked local government regulators have moved beyond threats to official action, employing the machinery of the state in a coordinated campaign to damage Disney's ability to do business in Florida. State leaders have not been subtle about their reasons for government intervention. They have proudly declared that Disney deserves this fate because of what Disney said. This is as clear a case of retaliation as this court is ever likely to see. At the governor's behest, the state legislature first voted to dissolve the long-standing RCID, then ultimately voted to give near complete control of RCID to the governor himself. As the Florida representative who introduced the Reedy Creek dissolution bill declared at the Florida House State Affairs Committee, "You kick the hornet's nest, things come up. And I will say this, you got me on one thing. This bill does target one company. It targets the Walt Disney Company." Disney has never wanted a fight with the Florida government. The company sought to de-escalate the matter for nearly a year, trying several times to spark a productive dialogue with the DeSantis administration, to no avail. Amid great uncertainty about the lengths to which the Senate would go to keep punishing Disney for its views, Reedy Creek and the company gave public notice in January of 2023 that they would enter into contracts to secure future development for the district and Walt Disney World, contracts that implemented a comprehensive plan for the district that the DeSantis administration itself had found compliant with Florida law months earlier. Through the development plan and implementing contracts, Disney set huge goals for itself and laid foundations for spectacular economic growth in Central Florida. Disney plans to invest over $17 billion in Walt Disney World over the next decade. The company estimates that those investments will create 13,000 new Disney jobs in that same 10-year period. Big goals aside, these contracts are land use agreements between a developer and its local regulator. They are similar in character to contracts between other developers and special districts to fix long-term development rights and obligations, thereby facilitating the certainty needed to ensure investment and affect commercial progress. Contrary to misunderstandings and mischaracterizations by some government leaders, they do not undermine the newly constituted Central Florida Tourism Oversight District Board's ability to govern or exercise authority, including by imposing taxes, exercising the power of eminent domain, approving or disapproving building permit applications, including projects carried out pursuant to the development agreement, building roads, providing emergency services, or issuing bonds. Moreover, nothing about these contracts was a surprise. They were discussed and approved after open, noticed public forums in compliance with Florida law. And in the very same legislation that replaced the elected board governing Disney with board members picked by the governor, the state legislature reaffirmed the enforceability of all prior contracts, including those here. It is a clear violation of Disney's federal constitutional rights under the Contracts Clause, the Takings Clause, the Due Process Clause, and the First Amendment, for the state to inflict a concerted campaign of retaliation because the company expressed an opinion with which the government disagreed. And it is a clear violation of these rights for the Tourism Board to declare its own legally binding contracts void and unenforceable. Disney thus seeks relief from this court in order to carry out its long-held business plans. Disney finds itself in this regrettable position because it expressed a viewpoint the governor and his allies did not like. Disney wishes that things could have been resolved a different way, but Disney also knows that it is fortunate to have the resources to take a stand against the state's retaliation, a stand smaller businesses and individuals might not be able to take when the state comes after them for expressing their own views. In America, the government cannot punish you for speaking your mind. And that's a really important reminder about the First Amendment. I see it a lot, especially on this channel. People who have a poor take or poor understanding of the First Amendment, thinking that Twitter can't censor whatever they want to censor or whatever. Yeah, it might be unfair in like the greater sense of the thing, but it's not illegal. However, The real meaning of the First Amendment, or rather the free speech part of the First Amendment, is that the government can't abridge your right to your freedom of speech, meaning there cannot be consequences for your freedom of speech from the government. So there can be consequences, and this is the major misunderstanding, the myth about the First Amendment. You can have consequences from everyone else, including other governments, but you're not allowed to have any consequences, any legal consequences, criminal charges, really any retaliation whatsoever from the federal or state or local U.S. government institutions in the United States under the First Amendment. That's what the First Amendment prevents. So skipping the parties, now we get to the detailed factual background. This is going to fill in a lot of details that if you hadn't been following every step of this, now you'll have every step of it. In 1963, Walt Disney looked down on acres of undeveloped Central Florida land from an airplane seat and saw potential. Disney quickly acquired title or options for over 27,000 acres of land comprising roughly 43 square miles in Central Florida. In 1966, the state created the Reedy Creek Drainage District, which allowed Disney, the largest landowner, to begin the effort of draining and reclaiming land so that actual site construction would be possible. The following year, the Florida legislature expanded the scope of the district's authority, establishing the Reedy Creek Improvement District through the Reedy Creek Enabling Act. In the Enabling Act, the legislature recognized that the economic progress and well-being of the people of Florida depend in large measure upon the many visitors and new residents who come to Florida. And to that end, the legislature granted Reedy Creek powers, functions, and authorities necessary to foster a recreation-oriented community that would enable enterprises to undertake a broad and flexible program of experimentation and development. RCID was tasked with providing for the reclamation, drainage, and irrigation of land, water and sewer systems, and waste collection and disposal facilities, public transportation and public utilities, and streets, roads, and bridges. So if that sounds an awful lot like a town, that's a town. You might remember from our discussions of company towns and all that it is possible for a company to take over the functions of a government in running a town, and the company just has to run a town the same way the government would run a town, and they're subject to the same constitutional requirements and all that as any other publicly owned town. But a privately owned town is fine. It's still subject to the Constitution. So this would be something where citizens still have rights, the same rights as they would anywhere else. It's just that Disney's a private company running the thing. I mean, it's a publicly owned company. This is where the public-private words start to break down. It's a publicly owned company, but it is a private organization, not a government organization. The legislature determined that the purposes of the act could not be realized except through a special taxing district having these powers. In 1968, the state of Florida challenged the RCID's power to issue drainage bonds. The state argued that because Disney was the largest landowner, the water control improvements funded by the bonds would impermissibly put public funds to a private purpose. The Florida Supreme Court rejected the challenge, finding the RCID served a public purpose. In particular, it concluded that the purpose of the RCID was essentially and primarily directed towards encouraging and developing tourism and recreation for the benefit of the citizens of the state and visitors to the state generally. The Florida Supreme Court also confirmed that the legislature had properly established the RCID, explaining that the legislature, in the exercise of its plenary or broad authority, may create a special improvement district encompassing more than one county and possessing multi-purpose powers essential to the realization of a valid public purpose. The court further emphasized that while RCID's powers over land use and economic development were broad, they were not commensurate in scope with those characteristic of a local municipal government, and were not a mere subterfuge to avoid the creation of a municipality. In the decades that followed, RCID has played a critical role in providing vital services for tourism in Central Florida. RCID enforces building codes, provides emergency services, and offers utilities subject to the oversight of state and federal regulators. Under state law, special district board meetings are open to the public, and districts provide reasonable notice of and produce minutes of each meeting. These records are open for public inspection. Today, the area formerly governed by the RCID, now governed by the Central Florida Tourism Oversight District, encompasses approximately 25,000 acres of land and covers portions of Orange and Osceola counties. The district employs hundreds of employees responsible for stewarding the land, consistent with environmental regulations and public safety. The district has built 134 miles of roadways and 67 miles of waterways. It has managed 60,000 tons of waste. It recycles 30 tons of aluminum, paper, steel cans, cardboard, and plastic containers every year. It uses thousands of vendors, suppliers, and contractors to provide a high level of public services for visitors. Disney is the primary landowner in the district and, as a result, is its largest taxpayer. For the 2022 fiscal year, Disney-owned land constituted 87% of the total taxable assessed value within the district. Like many other special districts in Florida, RCID board members were, until recently, elected on the basis of property ownership within the district. As RCID's largest landowner and taxpayer, Disney naturally had substantial input into RCID's acquisition of property, development of transportation facilities, operation of public utilities, and issuance of revenue bonds, among other things. Disney, since the beginning, was the primary contributor to the unprecedented success of the RCID's development objectives. Under Florida's Community Planning Act, a special improvement district is required to adopt a comprehensive plan that guides future growth and development. Comprehensive plans include elements addressing affordable housing, transportation, infrastructure, conservation, recreation, and open space, intergovernmental coordination, and capital improvements. Florida law also requires that special districts review their comprehensive plan every 7 years to determine whether amendments are necessary. The current comprehensive plan is the RCID Comprehensive Plan 2032. RCID and Disney began collaborating years ago in 2018 to settle on the amendments captured in the comprehensive plan. Among other things, the comprehensive plan details maximum development limits down to the square foot through 2032 for hotels, office space, retail, and restaurants and theme parks. On May 25, 2022, RCID held a public hearing on the comprehensive plan. At that hearing, RCID's planning and engineering team advised that the contemplated amendments would bring the comprehensive plan up to 2032. After discussing questions from the board and soliciting public comments, there were none, the board unanimously approved the comprehensive plan. The city councils, Bay Lake and Buena Vista, each unanimously approved the comprehensive plan the day before. Shortly thereafter, on June 2nd, RCID submitted the comprehensive plan to the state's Department of Economic Opportunity for review. By letter dated July 15th, the department confirmed that it had reviewed the amendment in accordance with the state coordinated review process and had determined that the adopted amendment meets the requirements. The department thereby determined that, among the many other legal requirements, it satisfied the plan properly set forth the principles, guidelines, standards, and strategies for the orderly and balanced future economic, social, physical, environmental, and fiscal development of the area that reflects community commitments to implement the plan and its elements. By statute, an affected person can file a challenge to the plan amendment. A petition challenging a comprehensive plan amendment must be filed within 30 days after the plan amendment is adopted. No petition was filed, and the comprehensive plan became effective on July 15th, 2022. So what I'm hearing so far is that this, ambush of contracts that Disney is accused of, that we all heard of from the media just a few weeks ago, was actually in place months, if not years ago, was already started and working its way through. So if you knew a regime change was coming and you had years-long plans in place that needed to be sort of signed off on and solidified, you'd get that done before the regime change too. So I'm not a big fan of Disney, but this is clever. The mouse is clever, guys. I mean, it's true. Now they get to the public comments on the Don't Say Gay bill. The Florida legislature passed the Parental Rights in Education Act in March of 2022. The public discussion before and after the bill's passage was robust, not only in Florida but across the country. Commentary came from all corners, including leaders of global corporations and editorial boards of major newspapers. As a Florida corporation and taxpayer with tens of thousands of Florida-based employees, Disney took an interest in the bill. On March 9th, the then CEO of Disney's parent company, the Walt Disney Company, called Governor DeSantis personally to express the company's concern. So before they made public comments, they called Governor DeSantis personally. Governor DeSantis recounts thinking that it was a mistake for Disney to get involved, and telling Disney's then CEO, "You shouldn't get involved. It's not going to work out well for you." On March 10th, Governor DeSantis' campaign sent an email accusing woke Disney of echoing Democrat propaganda. Walt Disney World issued the following statement shortly thereafter. "To all who come to this happy place, welcome. Disney Parks Experiences and Products is committed to creating experiences that support family values for every family and will not stand for discrimination in any form. We oppose any legislation that infringes on basic human rights and stand in solidarity and support with our LGBTQIA+ cast, crew, and Imagineers and fans who make their voices heard today and every day." Governor DeSantis signed House Bill 1557 into law March 28th. That day, the Walt Disney Company issued a statement expressing its views that the legislation should never have been signed into law, that its goal as a company is for this law to be repealed by the legislature or struck down in the courts, and that the Walt Disney Company remains committed to supporting the national and state organizations working to achieve that. On March 29th, Governor DeSantis said that he thought the Walt Disney Company's March 28th statement had crossed the line and pledged to make sure we're fighting back in response to Disney's protected speech. Governor DeSantis' memoir attacked Disney's speech and petitioning activity for expressing the wrong viewpoint. In promising to work to repeal the bill, he asserted, the company was pledging a frontal assault on a duly enacted law of the state of Florida. As a consequence of its disfavored speech and petitioning, he declared, things got worse for Disney. The governor promptly began his campaign of punishment. Next, the governor dissolves the Reedy Creek Improvement District. On March 30th, State Representative Spencer Roach disclosed for the first time that the legislature was considering dissolving the Reedy Creek Improvement District and announced, if Disney wants to embrace woke ideology, it seems fitting that they should be regulated by Orange County. Governor DeSantis had been orchestrating the move behind the scenes. As he recounts in his memoir, I needed to be sure that the legislature would be willing to tackle the potentially thorny issue involving the state's most powerful company. I asked the House Speaker, Chris Sprowls, if he would be willing to do it, and Chris was interested. Okay, here's the deal, I told him. We need to work on this in a very tight circle. There can be no leaks. We need the element of surprise. Nobody can see this coming. Now, if you're wondering where these quotes come from, they are directly from The Courage to Be Free, written by Ron DeSantis in 2023, or released in 2023. On March 31st, Governor DeSantis quickly affirmed Representative Roach's statement, saying publicly, we're certainly not going to bend a knee to woke executives in California. That is not the way the state's going to be run. On April 19th, Governor DeSantis suddenly called for the legislature to expand a special session that had been scheduled to address redistricting. The new purpose of the session was to attack Disney by targeting just the handful of Florida's more than 1,000 independent special districts that were created before the passage of the 1968 Florida Constitution, like Reedy Creek. Governor DeSantis conjured other rationales for the bill, including to ensure that independent special districts are appropriately serving the public interest, and to consider whether such independent special districts should be subject to the special law requirements of the Florida Constitution of 1968 that prohibit special laws, granting privileges to private corporations. These rationales did not make sense. Only 6 independent special districts that were created before 1968 had not been reconstituted in the intervening years. Of those, RCID was the only district closely connected to a specific corporation. And in Governor DeSantis' memoir, he admitted that he found that there was this handful of other districts that also deserved scrutiny only after his staff worked with the legislative staff in the House to target Disney. When considered against the substance of the legislation, the pretext became especially transparent. The bill did nothing either to ensure that the independent special districts are appropriately serving the public interest, or consider whether such independent special districts should be subject to the special law requirements of the Florida Constitution of 1968 that prohibit special laws granting privileges to private corporations. Instead, under the bill, districts created before 1968 were preemptively scheduled for dissolution before the legislature undertook any analysis to determine whether the districts were serving the public interest, and before any determination as to whether they were subject to the special law requirements of the Constitution at all. Had the legislature undertaken that analysis, it would necessarily have found that RCID served the public interest, as the Florida Supreme Court had already confirmed, and further that RCID was not subject to the 1968 Constitution's prohibition on special privileges granted to private corporations, rejecting as untenable the claim that Reedy Creek's Enabling Act's provisions were oriented to serve the benefit of a particular private enterprise. Again, it's basically a privately owned town. And so there is this sort of constant awareness of a conflict between the private corporation and the public nature of the town. On April 20th, 2022, Governor DeSantis sent a fundraising email warning that Disney and other woke corporations won't get away with peddling their unchecked pressure campaigns any longer, and that he would not allow a woke corporation based in California to run our state. The campaign against Disney raced forward. The very same morning that Governor DeSantis issued his proclamation expanding the special session, identical bills were introduced in the Florida House and Senate providing for the dissolution of the RCID. Florida House Bill 3C and Florida Senate Bill 4C each provided that any independent special district established by a prior special act to the date of ratification of the Florida Constitution, which was not reestablished, re-ratified, or other reconstituted by a later special act, is dissolved, effective June 1st, 2023. House sponsor Representative Randy Fine immediately announced, "Disney is a guest in Florida. Today we remind them. Governor DeSantis just expanded the special session so I could file HB 3C, which eliminates Reedy Creek Improvement District, a 50-year-old special statute that makes Disney too exempt from laws faced by regular Floridians." That same day, Representative Fine said to the Florida House State Affairs Committee, "You kick the hornet's nest, things come up, and I will say this, you got me on one thing. This bill does target one company. It targets the Walt Disney Company." Governor DeSantis' memoir describes the attack on Disney with pride. "Nobody saw it coming," he said, "and Disney did not have enough time to put its army of high-powered lobbyists to work to try to derail the bill. That the legislature agreed to take it up would have been unthinkable just a few months before. Disney had clearly crossed the line in its support of indoctrinating very young schoolchildren in woke gender identity politics." The legislative process for Senate Bill 4C was highly unusual. When in the past the Florida legislature had dissolved a special district, the bills enacting the dissolution typically specified the plan for governance and management of district assets and obligations, including bond debt after dissolution. Senate Bill 4C, in stark contrast, described no plan for the disposition of RCID's assets, operations, or obligations, nor did the bill address how RCID's roughly $1 billion in municipal bond debt would be satisfied. The legislative analysis accompanying the bill was cursory and provided no estimate of the full economic impact of dissolving the RCID. The analysis identified no constitutional issues raised by the legislation. On April 20th, the Senate passed Bill 4C. The House followed suit without legislative findings or a statement of purpose. The very next day, in a session without debate that lasted under 5 minutes. Orange and Osceola counties did not have time to conduct their own analyses. After the vote, Senator Joe Gruters said Disney is learning lessons and paying the political price of jumping out there on an issue. The House bill sponsor, Representative Fine, proudly confirmed that the legislature had looked at special districts only because Disney kicked the hornet's nest by expressing a disfavored political viewpoint. What changed, he said, was bringing California values to Florida. Christina Pushaw, Then Governor DeSantis' press secretary warned corporations that might consider expressing disfavored viewpoints, go woke, go broke. On April 22nd, Governor DeSantis signed both Senate Bill 4C and Senate Bill 6C. At the signing ceremony, he said, for whatever reason, Disney got on that bandwagon. They demagogued the bill. They lied about it. Do you know what my view is? I was very clear about saying, you ain't influencing me. I'm standing strong here. We signed the bill. And then, and incredibly, they say, we are going to work to repeal parents' rights in Florida. And I'm just thinking to myself, you're a corporation based in Burbank, California, and you're going to marshal your economic might to attack the parents of my state? We view that as a provocation, and we are going to fight back against that. Because the legislation was hastily enacted with no analysis or plan for disposition of RCID's assets or obligations, let alone daily operations, markets, constituencies, and RCID employees were concerned. The same day the bill was signed, credit rating agency Fitch Ratings placed RCID's approximately $1 billion in outstanding bond debt on Rating Watch Negative, based on the lack of clarity regarding the allocation of RCID's assets and liabilities. Speculation spread that Orange and Osceola counties would absorb RCID's expenses and debts. Orange County tax collector Scott Randolph predicted that Orange County would be saddled with RCID's obligations the minute that Reedy Creek is dissolved, resulting in a property tax increase of 20 to 25%. Senator Linda Stewart addressed this possibility. Turning it over to Orange County and Osceola County would create the largest property tax increase in our history. We don't want that to happen. Our residents do not want this to happen. This has not been well thought out. At the same press conference, Senator Randolph Bracy called the plan harebrained and irresponsible, while Senator Victor Torres criticized Governor DeSantis for bragging about raising taxes on one of the largest private companies in the state and saying government has the right to punish companies for their private business decisions. On May 16th, residents and taxpayers in Osceola County filed a lawsuit against Governor DeSantis, alleging that the dissolution of Reedy Creek would lead to $1 to $2 billion in increased taxes for residents of Central Florida. Despite the chaos, the legislation's biggest boosters doubled down on their support. The House sponsor, Representative Fine, criticized Disney for taking a position on House Bill 1557 and warned that the company, and others like it, are now learning, in Florida, there's a cost to doing that. In a June 6 interview, Governor DeSantis recalled that he had warned Disney not to participate in the public debate. I thought it was a mistake for Disney to get involved, and I told them, you shouldn't get involved. It's not going to work out well for you. Governor DeSantis said that he believed it was his role as a leader to make sure people understand that Disney does not run the state of Florida, adding that we're not going to have our leadership subcontracted out to a corporation with close ties to the Chinese Communist Party, and that's based in Burbank, California. During a September 15th, 2022 speech, Governor DeSantis said of Senate Bill 4C, we took action after Disney made the mistake of opposing the legislation. For months, no plan for implementing Senate Bill 4C was released. As late as mid-September 2022, Governor DeSantis' press secretary told reporters, we don't have an announcement to make at the moment about RCID, but stay tuned. Absent any plan addressing the scheduled dissolution of RCID, Disney and other stakeholders were left to guess at how Governor DeSantis and the legislature might address the fallout. Florida Division of Bond Finance Director J. Ben Watkins III speculated about a successor district, but as of September 2022, high-ranking legislator Representative Daniel Perez admitted that the timeline for reaching a solution was still uncertain. The months-long failure to propose a plan for the dissolution of RCID threatened Disney's operations, investments, and development plans. It also underscored the irregular process by which Governor DeSantis and the legislature had voted to abolish the district. All right, we're about halfway through. How you doing so far? This is pretty remarkable. This is a lot of evidence. Assuming that these things are true, and I think these are Governor DeSantis' own words in his own book. He really didn't think this through about First Amendment retaliation. He really, really, really didn't think it through, that he's giving Disney all of this evidence to use against him in their lawsuit, alleging not just First Amendment retaliation, but also contract violations, due process violations, taking clause violations. It's a pretty well thought out and pretty clever lawsuit. When you hear rumors or gossip about how the Mouse's lawyers know what they're doing, yeah, these lawyers have written a very, very good complaint here. I do not see how this is anything but rock solid, and I don't see how the district court can do anything but rule against Ron DeSantis. So now on to the part where the governor seizes control of the district. In early October 2022, reports emerged that Governor DeSantis finally had developed a plan to seize control of Disney's governing body. The director of the Florida Division of Bond Finance revealed that Governor DeSantis would install state appointees on RCID's board. To accomplish this, Governor DeSantis would have the legislature create a successor agency that would function essentially unchanged from the original, except that the new district would operate under the governor's thumb, cementing a political win for the governor. 3 months later, Governor DeSantis posted a notice to the Osceola County website indicating his intent to seek legislation before the Florida legislature, doing just that. In a statement after the notice was published, the governor's communication director confirmed that the new district's board would be state-controlled and heralded. The corporate kingdom has come to an end. On January 31st, 2023, a spokesman for the governor's office announced that the governor expected a special session of the legislature the following week on Reedy Creek and other items. Right on cue, the Florida legislature convened a special session to introduce House Bill 9B, which was every bit the takeover that Governor DeSantis promised. Section 2 of the bill reenacted RCID's charter but made key changes to consolidate power in the governor. Historically, the district has been governed by a board of supervisors that exercised the powers granted to the district. Under RCID's charter, board members were chosen through an election in which all landowners in the district were allotted 1 vote per acre of land owned in the district. Of course, Disney's the largest landowner. We know how that works out. This structure, common in special districts for economic development throughout Florida, was no secret and was in place when the Florida's Supreme Court long ago confirmed that RCID served a public purpose. House Bill 9B replaced that landowner election process with a board, handpicked by the governor, subject to confirmation by the Florida Senate. Once selected, board members could serve for up to 12 years. The bill excluded from board service any person who, in the last 3 years, had worked for any organization that owns a theme park or entertainment complex with at least 1 million annual visitors. It also excluded any person with a relative who had done the same. In one important respect, things remained unchanged. The bill left RCID's financial and contractual obligations intact. In particular, contracts that RCID entered before House Bill 9B's effective date would be unaffected, as the legislation expressly made clear. Specifically, all pre-existing contracts, debts, bonds, and other liabilities, quote, shall continue to be valid and binding on the Central Florida Tourism Oversight District in accordance with their respective terms, conditions, and covenants, end quote. Underscoring the point, the bill added, the provisions of this act shall be liberally construed in favor of avoiding any events of default or breach under outstanding bonds or other instruments of indebtedness of the district's existing and legally valid contracts. House Bill 9B prevented the district's dissolution, which had been set to occur on June 1st under Senate Bill 4C. It reaffirmed the district's continued existence under a new name, however, the Central Florida Tourism Oversight District. House Bill 9B was a law designed to target Disney and Disney alone. It shifted the power to select the district's board from the district's landowners, including its majority landowner Disney, to the governor to enable him to punish Disney for its protected speech about House Bill 1557. In comments to reporters on February 8th, Governor DeSantis said, "There's a new sheriff in town, and that's just the way it's going to be." The legislature passed House Bill 9B within days of its special session introduction. During the Florida Senate's February 10th floor session, Senator Doug Broxson underscored what the plan was from the start. House Bill 9B was bare retaliation for Disney's failure to be apolitical. Senator Broxson was explicit about the bill's retaliatory intent. We joined with the governor in saying it was Disney's decision to go from an apolitical, safe 25,000 acres and try to be involved in public policy. We're saying you have changed the terms of our agreement, and therefore we will put some authority around what you do. And I gladly joined the governor in doing that. On February 27th, Governor DeSantis signed House Bill 9B into law. In a related news release, the governor praised the legislation for ending the corporate kingdom of Walt Disney World and placing the district into state receivership. The very next day, Governor DeSantis published his book, titled The Courage to be Free, Florida's Blueprint for America's Revival. To kick off the book's press tour, Governor DeSantis authored an opinion piece in the Wall Street Journal that explicitly connected House Bill 9B to Disney's speech about House Bill 1557, criticizing what he called left-wing activists working at Disney's headquarters in Burbank. I need to stop you. He keeps saying this thing about how Disney is based in Burbank. Yes, that's true. Corporations have like a home base and all that. But we're talking about a very, very, very large corporation in Central Florida where these people live. The whole kingdom thing, Disney Magic Kingdom and Disney World and all that is not run by one person in Burbank or 100 people in Burbank, although they may be the people at the top of the hierarchy. That's very true. But you've got thousands and thousands and thousands of employees that are Central Florida residents, that are citizens, Florida citizens, that are Florida voters, and you're throwing them all out like this. I don't understand it. I mean, except out of the context of it's just a power grab. Criticizing what he called left-wing activists working at Disney's headquarters in Burbank, Governor DeSantis focused on Disney's opposition to Florida's House Bill 1557 and said, "When corporations try to use their economic power to advance a woke agenda, they become political and not merely economic actors. In such an environment, reflexively deferring to big business effectively surrenders the political battlefield to the militant left. Leaders must stand up and fight back when big corporations make the mistake, as Disney did, of using their economic might to advance a political agenda. We are making Florida the state where the economy flourishes because we are the state where woke goes to die." Indeed, Governor DeSantis has reaffirmed again and again that the state campaign to punish Disney for its speech about House Bill 1557 has been a coordinated and deliberate one from the start. Disney's commentary on the Don't Say Gay bill, he claimed, was a declaration of war and a textbook example of when a corporation should stay out of politics. So now Disney's going to talk about those long-term land use contracts. Despite the state's escalating retaliation, Disney sought de-escalation, including through several attempts to spark a productive dialogue with the DeSantis administration. It was to no avail. The threatening political action and rhetoric continued and escalated further. So, amid great uncertainty, Disney and RCID sought to secure future development plans that had been mutually arranged. They executed two agreements, a Chapter 163 development agreement, we're going to call it the development agreement, and a declaration of restrictive covenants, the restrictive covenants we're going to call it, and it's called the contracts together. So, development contracts. Private developers face enormous risk. They invest heavily in long-term projects that depend for their viability on stable government oversight and regulation. That is especially the case for Disney, and Disney's goals with the contracts at issue in this case underscore the point. The company seeks to invest up to $17 billion in capital and create roughly 13,000 new jobs in the region over the next decade. Development and investment of this magnitude cannot effectively take place when it can be nullified or undermined at the whim of new political leadership. Thus, because a development project often extends throughout several local or state administrations with potentially differing regulatory objectives, developers commonly rely on contract law to secure their investments over time. Florida understands this well. Decades ago, the legislature specifically authorized local governments to enter into contracts with private developers through the Florida Local Government Development Agreement Act. In enabling the Development Agreement Act, The legislature found and declared that the lack of certainty in the approval of development can result in a waste of economic and land resources, discourage sound capital improvement planning and financing, escalate the cost of development, and discourage commitment to comprehensive planning. The legislature explained that its intent in enacting the Development Agreement Act was also to encourage a stronger commitment to comprehensive and capital facilities planning, ensure the provision of adequate public facilities for development, encourage the efficient use of resources, and reduce the economic cost of development. In the legislature's own words, this intent is affected by authorizing local governments to enter into development agreements with developers. A restrictive covenant is another type of contract that facilitates efficient, productive, and profitable long-term land use. Restrictive covenants are agreements between two parties by which one party agrees to refrain from using property in a particular manner, ultimately to the benefit of both parties. Florida enforces restrictive covenants in order to provide the fullest liberty of contract and the widest latitude possible in disposition of one's property. As any prudent developer would do, and as many others have done, with no controversy, Disney used these tools to secure future development plans, which the DeSantis administration had already found compliant with Florida law in the comprehensive plan. The contracts followed public notices in the Orlando Sentinel, Orlando's primary newspaper with readership in the hundreds of thousands, and discussion at public hearings. On January 18, 2023, RCID issued its first public notice in the Orlando Sentinel. Notice is hereby given that the Reedy Creek Improvement District will hold the first of two public hearings on January 25, 2023, on the intent to consider a development agreement pursuant to Chapter 163 Florida statutes, and the publication continued with the specifics about the contract terms. In accordance with the Orlando Sentinel notice, RCID considered the development agreement at the January 25th public hearing. As reflected in the minutes, attendees included representatives from various news channels and the Orlando Business Journal. The district administrator advised that the board is being asked to consider a proposed development agreement between the district and Disney. He explained several key provisions of the agreement, including that it would vest development entitlements in Disney as the owner of the vast majority of the lands within the district and the master developer of the Walt Disney World Resort. The RCID board president asked if there were any public comments. There were none. After that discussion and opportunity for public comment, RCID gave notice that the matter would be on the agenda again for the next public meeting set for February 8th. 2 days after the first public hearing, RCID published a second notice in the Orlando Sentinel. Notice is hereby given that the Reedy Creek Improvement District will hold the second and final of two public hearings on February 8th on the intent to consider a development agreement pursuant to Chapter 163 Florida statutes, and again continuing with accompanying specifics about the contract terms. In accordance with that Orlando Sentinel notice, RCID considered the matter for a second time at the February 8th public hearing. As reflected in the minutes, attendees again included representatives from several news outlets, including the Orlando Business Journal. The district administrator advised that there had been no changes to the development agreement since the previous meeting. He added that this February 8th meeting was the second of two public hearings required to approve the development agreement. The RCID board president asked if there were any public comments, and there were none. Upon a motion to approve the development agreement and a second to the motion, the RCID board unanimously approved it. At the February 8th meeting, the district administrator also requested board approval and authorization to sign a declaration of restrictive covenants. He explained that the restrictive covenants are associated with the developer's agreement. He then described several provisions of the restrictive covenants. The RCID board president asked if there were any public comments, and again, there were none. Upon a motion to approve the restrictive covenants and a second to the motion, the RCID board unanimously approved them. Disney and RCID executed the contracts that same day, February 8th, and then recorded them in official county records. The terms. The contracts are interrelated and each serves to the benefit of both Disney and the district for long-term development planning. Much has been mischaracterized about the intent and effect of the contracts. The contracts do not undermine the CFTOD's board ability to exercise its limited governing powers. Indeed, among other things, the board maintains the ability to 1. Impose ad valorem taxes, maintenance taxes, and utility taxes, including the power to enforce collection of taxes by liens and foreclosure. 2. To build, operate, and maintain roads. 3. To provide emergency services. 4. To exercise the power of eminent domain. 5. To maintain and operate the extensive drainage and flood control system and other utilities. 6. Adopt, supplement, and enforce codes regulating building safety, elevators, escalators, and similar devices, the prevention of fire hazards, plumbing, and electrical installations, and the like. 7. To review and approve or disapprove building permit applications. And 8. Issue general obligation bonds, revenue bonds, utility service tax bonds, and bond anticipation notes. Rather, the contracts reflect in significant part confirmations of the comprehensive plan that had already been reviewed by RCID and the state of Florida in July of 2022. The development agreement precludes Disney from using its land except as authorized in the development agreement, which permits Disney to use the lands within the district up to a defined maximum development program. Down to the square foot, the maximum development program specifies how much mixed-use commercial space for offices and retail and restaurants Disney can build through 2032. The maximum development program also approves 1 additional major theme park and 2 additional minor theme parks for construction through 2032. Finally, the maximum development program approves 14,000 additional keys for hotels and resorts. Thus, the maximum development program tracks the planning set forth in the comprehensive plan. All development rights and entitlements as established by the maximum development program are vested in Disney. The development agreement further provides that any proposed development utilizing the maximum developer program must follow developer review and approval process defined in the district's land development regulations. The agreement recognizes that the maximum development program will require new or expanded facilities in public infrastructure systems and requires that the district shall fund, design, and construct those facilities. Thus, with respect to any land owned by Disney's that is needed for public facilities, Disney agrees to sell its land to the district instead of the district having to go through condemnation proceedings, and agrees not to seek payment from the district in excess of the land's fair market value. Finally, as the development agreement recognizes, Disney and the district previously collaborated in the procurement of federal and state-level environmental permits, entitling RCID land to certain unique and beneficial development rights. Specifically, Disney sought and received, primarily at Disney's expense, approvals governing the protection and relocation of threatened and endangered species and requisite mitigation for the same. Disney similarly pursued and received approval of a comprehensive and forward-looking federal dredge and fill entitlement framework, creating a site-specific wetland credit mitigation bank via the acquisition, restoration, and perpetual management of what is now known as Disney's Wilderness Preserve and Mar-a-Lago, again at Disney's expense. Given all that, the development agreement confirms certain mitigation credits are vested in Disney, and that Disney is solely entitled to use them. For long-term stability, the development agreement has a duration of 30 years from its effective date and may be extended. The restrictive covenants provide that the standards under which the district's properties exist as of the restrictive covenant's effective date shall be maintained. Under the restrictive covenants, the exterior design, appearance, and exterior aesthetic qualities of any improvements to any portion of the district's properties are subject to Disney's prior review and comment, which Disney cannot unreasonably withhold, condition, or delay. In relation to the district's properties, the restrictive covenants provide that the district shall not use names or symbols associated with Disney without Disney's express prior written approval, use fanciful characters such as Mickey Mouse or other intellectual property in design, symbols, or other representations created by Disney, sell or distribute merchandise, souvenirs, or other items referring to Disney properties, or reproduce, sell, distribute, or display any work copyrighted by Disney. And now the part where Governor DeSantis replaces the board members with his appointees, and then they void the contracts. On February 27th, 2023, the date Governor DeSantis signed House Bill 9B into law, and 3 weeks after the contracts were executed, following public notice and hearing, Governor DeSantis announced the names of the 5 individuals he had selected to replace the elected members of the board. When Governor DeSantis addressed what he was looking for with this board, he described, with thinly veiled euphemism, staffing the board with people who would censor Disney's speech and discipline the company. As Governor DeSantis put it, referring to Disney, when you lose your way, you've got to have people that are going to tell you the truth, so we hope they can get back on. Governor DeSantis also posited that the new board could stop Disney from trying to inject woke ideology into children. As Governor DeSantis put it, I think all of these board members very much would like to see the type of entertainment that all families can appreciate. The new members of the board sat for their first meet. Wait, so was he saying that he's hoping that this will prevent Disney from releasing, like, movies and shows and content that has diversity, has homosexual or bisexual or other LGBTQ membership in it, or other whatever he defines as woke ideology is no longer going to be in Disney content? Wow, you want to talk about viewpoint-based discrimination? Yeah, they're checking all the boxes here and then some. My bingo card is full, like the whole card, not just one row. The new members of the board sat for their first meeting on March 8th, 2023. At that meeting, one board member suggested that 2 cities comprising Disney's property, Bay Lake and Lake Buena Vista, should be dissolved, despite the fact that the board has no authority or mandate to dissolve the cities. Another hinted at plans to make major changes, but did not go into detail. The board also approved hiring the same legal counsel that had advised Governor DeSantis' office on House Bill 9B. Following the meeting, Disney released the following statement, holding on to hope that, despite the board's origins and Governor DeSantis' directives, the board might be willing to forego its mandate to punish Disney and focus instead on the economic welfare of the district. Quote, the Reedy Creek Improvement District created and maintained the highest standards for the infrastructure for the Walt Disney World Resort. We're hopeful the new Central Florida Tourism Oversight District will continue this excellent work, and the new board will share our commitment to helping the local community continue to flourish and support the ongoing growth of the resort and Florida's tourism industry. Unfortunately, the district has embraced the governor's express mission to punish Disney for expressing disfavored viewpoints. On March 29th, CFTOD gathered for its second meeting. At that meeting, members claimed that they had just discovered the contracts, which had been publicized in the press, read out at board meetings, and recorded in county records almost 2 months earlier. The district's special counsel suggested that RCID should hire firms with a deeper bench going forward. I don't even know what that means. The next meeting was scheduled for April 19th. On the evening of March 29th, one board member denounced the arrogance of Disney, warning that the company has been ignoring parents and allowing radicals to sexualize our children, and was now ignoring Florida taxpayers by sneaking in a last-minute sweetheart development agreement, equating Disney's exercise of its rights under Florida law to enter long-term development agreements with Disney's exercise of its rights to speak on public issues. The same board member declared, Disney has once again overplayed their hand in Florida. We won't stand for this. We won't back down. A public narrative about these contracts quickly formed around the idea that Governor DeSantis was caught off guard and had the rug pulled from under him. Governor DeSantis' allies, including a state representative and another board member, in turn accused Disney of trying to pass an 11th-hour deal in the middle of the night and sneaking in the contracts. Echoing their calls, Governor DeSantis himself subsequently claimed that the contracts were uncovered and last minute. None of this was true. As explained, these contracts followed public notice, in the Orlando Sentinel no less, and public hearings. But despite the facts, the political story was set, and the retaliation only got worse. On April 3rd, Governor DeSantis lashed out at Disney by announcing the launch of a wide-ranging civil and criminal investigation, ostensibly triggered by the state's belated discovery of the contracts. Governor DeSantis directed his chief inspector general, Melinda Miguel, to probe any financial gain or benefit derived by Walt Disney World as a result of RCID's actions and justifications for such actions. All RCID board members, employees, or agents' communications related to the actions, including those with Walt Disney World employees and agents, and several other topics were set to be investigated. Governor DeSantis instructed Miguel to refer any legal or ethical violations to the appropriate authorities. 3 days later, on April 6th, Governor DeSantis stated at a public event that Disney had tried to pull a fast one. He added, "They are not superior to the people of Florida." Dude, they are the people of Florida. So come hell or high water, we're going to make sure that policy of Florida carries the day. And so they can keep trying to do things. But ultimately, we're going to win on every single issue involving Disney. I can tell you that. That story's not over yet. Buckle up. There's going to be more coming down that pike. In the question and answer session that followed, Governor DeSantis said that Disney is acting like somehow that they pulled one over on the state, and that now that Disney has reopened this issue, we're not just going to void the development agreement they tried to do. We're going to look at things like taxes on the hotels. We're going to look at things like tolls on the roads. We're going to look at things like developing some of the property that the district owns. On April 7th, addressing the contracts, Governor DeSantis stated at a press conference, "I think Disney has always viewed itself as being exempt from the constitutional process. Well, those days are over here in the state of Florida." Dude, like every accusation is just a projection. It's look in a mirror. Like, what do you mean you don't get to play by your own rules? Like, here the governor whose job it is to faithfully execute the laws is playing by his own rules. It's like, it's the hypocrisy is dripping off of this whole thing. There will be additional legislative action in Tallahassee that will nullify what they tried to do at the 11th hour and then potentially, arm the board with the ability to make sure that this is run appropriately. On April 13th, Governor DeSantis stated at a public event, "They're fighting us on this. The media is acting like Disney's getting out from under. No, it's not going to happen. We'll have the news on that next week, so stay tuned. There will be round 2 in terms of those fireworks," he added. "I don't care if Disney doesn't like it. They can take a hike." Governor DeSantis conveyed his total control over the board. Speaking on an Orlando radio program April 17th, he warned that the board would be meeting in a few days to make sure Disney is held accountable. He convened a press conference April 17th to discuss the next steps in the campaign against Disney. The steps included legislation and the legislative declaration by the district. He described the legislation as a bill that would make sure that the people understand that you don't get to put your own company over the will of the people of Florida. He added that efforts were underway to give the state new authority to override safety inspections at Walt Disney World, as well as to regulate Disney's monorail transportation system. Describing what his administration would do with land taken from Disney's control, he mused, "People are like, what should we do with this land? People have said, maybe create a state park, maybe try to do more amusement parks. Someone even said, like, maybe you need another state prison. Who knows? I just think the possibilities are endless." Governor DeSantis warned, "I look forward to the additional actions that the State Control Board will implement in the upcoming days." Representative Carolina Amnesty took the podium after Governor DeSantis concluded his remark. She reiterated the connection between the threatened board actions and Disney's protected speech. "Let it be known across this great nation that here in the free state of Florida, it is we the people, not woke corporations. We all love Disney, however, you cannot indoctrinate our children. Instead, they have turned Disney into this corporate PR arm of a small group of extremists who want to indoctrinate our children with radical gender ideologies that have no basis in science, common sense, or basic human decency. As our governor has said, Florida is a place where woke goes to die." Senator Blaise Ingoglia spoke next. He threatened, "I know this governor, and I know this governor well, so I have a couple of words for Disney. You are not going to win this fight. This governor will." At the conclusion of the press conference, Governor DeSantis stated, "Stay tuned, we've got more coming up." The governor's office issued a press release later that day announcing Disney's corporate kingdom is over and that the agreements will be nullified by new legislation that I intend to execute. I look forward to the additional actions that the State Control Board will implement in the upcoming days. The district met for its third meeting on April 19th. At that meeting, outside counsel attacked Disney's exercise of development contract rights and proclaimed that Disney's efforts are illegal and they will not stand, even though he acknowledged that it is well established under Florida law that a development agreement and restrictive covenant are contracts that are governed by the law of contract. District Council also admitted that Disney did publish notice in the newspaper before entering into the development agreement. When the district chair asked council what action he recommends the board take, the board's special counsel recommended the board move to direct council to prepare a resolution for consideration at the board's April 26th meeting that would declare the contracts void ab initio from the beginning, make findings of fact in support thereof, and direct action as needed to assert the district's positions on these issues. A motion in support of this action passed with unanimous support. Wow, these people think they have unlimited power. They don't even realize that they're a government entity that has a purpose in governing and has limited powers granted by the constitutions of the state of Florida and the United States. A motion in support of this action passed with unanimous support. The same day, the board published the agenda for the April 26th meeting. The agenda included a single item, new business, labeled Approval of Legislative Findings Regarding and Declare the Development Agreement and Declaration of Restrictive Covenants entered into by Reedy Creek Improvement District and Walt Disney Parks and Resorts, U.S., void, ab initio, and direction to litigation counsel regarding same. On April 24th, they published proposed legislative findings for its predetermined voiding of the contracts. The purported findings assert a scattershot collection of alleged contract infirmities and then declare the contracts to be void and unenforceable. Going further, the legislative findings and declaration attack the comprehensive plan, even though the state itself found the plan in compliance with Florida law months ago. The legislative findings and declaration also target certain land development regulation amendments that were recently adopted. The district gave no prior notice of its intent to void the comprehensive plan or the regulation amendments. The purpose and effect of this exercise of power is the same as the legislation and executive activity that has been deployed for over a year to punish Disney for expressing a certain view. On April 26, just as the district previewed it would do the week before, the board unanimously approved the legislative findings and declaration, declaring that the contracts were void and unenforceable. For extra measure, the Florida legislature has recently advanced legislation attacking the contracts, prohibiting their enforcement unless the district board were to readopt them. Underscoring the state's coordinated efforts, the district's legislative findings and declaration conclude the board has no desire to readopt or ratify the contracts. Indeed, the legislature does not seem intent on moderating its retaliatory campaign anytime soon. Recently proposed legislation would require oversight of monorail and other fixed guided transportation systems located within an independent special district created by local act, which have boundaries within 2 contiguous counties. A transparent attack on Disney and Disney alone. The legislation would even give the state authority to shut down systems during inspection. Having exhausted all other options, Disney is left with no choice but to bring this complaint, asking the court to stop the state of Florida from weaponizing the power of government to punish private business. So that's a lot. You might want to take a break and get up and walk around. But what we're going to get into next is the claims for relief, the causes of action. And these are pretty epic because you don't normally see a United States Constitution contract clause violation. So this is kind of a nerd out moment for us law geeks. We literally have the first cause of action is U.S. Constitution Article 1, Section 10, Contracts Clause violation. CFTOD's abrogation of the contracts violates Disney's rights under the U.S. Constitution, Article 1, Section 10, Clause 1, known as the Contracts Clause. The Contracts Clause provides that no state shall pass any law impairing the obligation of contracts. The Contracts Clause prohibits local government entities from abrogating their own contracts with private entities. In other words, a local government could just enter into a contract, gain the benefit of that contract, and then just void the contract and not pay. You can't do that. A law that impairs a government entity's own contracts with a private actor is especially suspect and hence subject to heightened judicial scrutiny. The rights protected by the Contracts Clause are familiar to Florida law. Indeed, the Florida Supreme Court has pronounced the right to contract to be one of the most sacrosanct rights guaranteed by our fundamental law. The legislative declaration violates that most sacrosanct right and thus deprives Disney of its rights under the Contracts Clause. By declaring the contracts void, the legislative declaration purports to rescind Disney's rights and protections under contracts and to relieve CFTOD of any obligation to comply with its obligations under the contracts or to pay damages for any breaches. The substantial, indeed total impairment of Disney's contract rights was not necessary to serve an important government interest, as required to survive Contracts Clause scrutiny. As alleged in this complaint, the contracts were abrogated as part of an explicit campaign of government retaliation against Disney for expressing a viewpoint the governor and legislature disagreed with. That objective is the opposite of important. It is categorically impermissible. So this is the test for, is government action permissible or not? And in fact, this government action is quite the opposite. It's impermissible, completely impermissible. Any other asserted reasons for abrogating the contracts are pretextual. RCID was fully empowered to enter into the contracts. Special districts commonly enter into contracts with developers, including special districts with governing structures defined by land ownership. And the law establishing CFTOD expressly provides that all pre-existing RCID contracts remain fully enforceable. Just as in other long-term development contracts in other special districts, the contracts here involve land use rights and obligations, not sovereign or police powers that special districts are legally barred from delegating. The contracts establish Disney's rights concerning use of its own property, as expressly authorized by RCID's charter, restrict CFTOD from using its own property for non-public purposes that interfere with Disney's development of its property. In exchange, the contracts restrict Disney's use of its own property to specified development purposes and obligate Disney to convey its property at fair market value when needed for public purposes. CFTOD has identified no reason or need to treat the contracts differently from long-term development agreements entered into by developers in other special districts. Even if CFTOD could articulate an important interest uniquely implicated by the contracts that is not implicated by other special district development contracts, they cannot show that complete abrogation of the contracts is necessary to serve any such interest. Under the Contracts Clause, the government is not free to impose a drastic impairment when an evident and more moderate course would serve its purpose equally well. An impairment of a contract is thus prohibited if a less drastic modification would have permitted the government to advance its purpose while allowing the contract to remain in place. The district has not identified any important government interest justifying its abrogation at all, much less an important interest that cannot be satisfied by modifying some provision or provisions of the contract. The district's decision to abrogate the contracts completely, rather than pursue modification of whatever provisions they claim to be unlawful, underscores its motivation to punish Disney for its political speech, rather than to operate as a good-faith counterparty in the continued development of the district. Disney is entitled to a declaration that abrogation of the contracts violates Disney's rights under the Contracts Clause, and that the contracts remain in effect and enforceable. Disney is further entitled to an order enjoining defendants from enforcing the legislative declaration. Next, they get into a takings clause violation. This is eminent domain. This is when the government takes your property. The legislative declaration takes Disney's property without providing just compensation in violation of the takings clause of the Fifth Amendment. The takings clause provides, "Nor shall private property be taken for public use without just compensation," Contract rights are a form of property and, as such, may be taken for a public purpose provided that just compensation is paid. Not all contract rights necessarily qualify as property under the Takings Clause, and thus the fact that legislation disregards or destroys existing contractual rights does not always transform the regulation into an illegal taking. But when a law overrides substantive contract rights in a specific real property, the clause's protections apply. The contracts secure valuable substantive rights in specific property, i.e. the parcels explicitly identified in the contracts. The development agreement, for example, grants Disney various long-term rights in the use and development of its land, consistent with the comprehensive plan found compliant with Florida law by the DeSantis administration. The restrictive covenants likewise protect Disney's rights to develop its land by limiting CFTOD's ability to use its adjacent lands in ways that damage or destroy Disney's development rights. The legislative declaration expressly deprives Disney of those valuable rights in private property without making any payment to Disney in exchange for the deprivation. The legislative declaration thus takes Disney's property without just compensation. Disney is entitled to a declaration that the taking of Disney property rights without payment of just compensation violates the Takings Clause, and that the property rights set forth in the contracts remain in effect and enforceable. Disney is further entitled to an order enjoining defendants from enforcing the legislative declaration. Next is a due process violation. So your right to, life, liberty, and due process of law. The legislative declaration abrogates the contracts without any rational basis and for only impermissible reasons in violation of the Due Process Clause of the 14th Amendment to the Constitution. The Due Process Clause provides no person shall be deprived of life, liberty, or property without due process of law. The Due Process Clause forbids any state or local entity from adopting any arbitrary or irrational legislative act affecting a person's state-created rights, including property interests. In other words, states must demonstrate that they are violating private interests only as necessary to promote state interests. The district cannot make that showing here. As alleged in this complaint, the legislative declaration purporting to abrogate the contracts was not enacted for any legitimate state interest. It was instead enacted to further an official state campaign of retaliation against Disney for expressing a viewpoint that Governor DeSantis and his legislative allies disagree with. Further, the district does not and cannot demonstrate that complete abrogation of the contracts is reasonably necessary to advance any state interest that could be legitimate. The district cannot show that the contracts are dissimilar in character to contracts between other developers and special districts to fix long-term development rights and obligations. Nor can the district show that the contracts contradict any aspect of the comprehensive plan found compliant by the state. The district thus cannot identify a non-arbitrary, rational basis for singling out and voiding the contracts. Disney is entitled to a declaration so, as well as an injunction. Now on to the First Amendment violations. So this is your right to freedom of speech. This is literally like the myth of free speech, that you have to be free from all consequences of your speech. No. The First Amendment is just that you are free from consequences from the government, and that's the situation that Disney finds itself in here. Disney's public statements on House Bill 1557 are fully protected by the First Amendment, which applies with particular force to political speech. See Citizens United. This is an actual proper use of Citizens United. Speech, such as Disney's on public issues and petitions to the government, occupy the core of the protection afforded by the First Amendment. The district's retaliatory interference with the contracts via the legislative declaration and its predicates has chilled and continues to chill Disney's protected speech. This unconstitutional chilling effect is particularly offensive here due to the clear retaliatory and punitive intent that has motivated the district's actions at the governor's directive. Disney has a significant interest in its own contracts, which have been directly targeted by the legislative declaration. Disney faces concrete, imminent, and ongoing injury as a result of the contractual impairment. The district's actions were motivated by retaliatory intent. On April 17th, DeSantis warned that the board would be meeting a few days later to make sure Disney is held accountable. The governor announced, "I look forward to the additional actions the State Control Board will implement." DeSantis has left no doubt to be harbored as to the impetus for his punishment. He wrote in an article to promote his book, "When corporations try to use their economic power to advance a woke agenda, they become political and not merely economic actors. Leaders must stand up and fight back when big corporations make the mistake, as Disney did, of using their economic might to advance political agenda." There is no rational basis to invalidate the contracts, and the purported justifications for doing so are pretextual. Because the legislative declaration retaliates, Disney is entitled to a declaratory judgment that the legislative declaration is unconstitutional and an order enjoining defendants from enforcing it. And there is another First Amendment violation. This one attacks Senate Bill 4C and House Bill 9B, claiming they were motivated by retaliatory intent. DeSantis would not have promoted or signed, and the legislature would not have enacted either bill but for their desire to punish Disney for its speech on an important public issue. Governor DeSantis called on the legislature to extend its special session for the express purpose of enacting Senate Bill 4C the very day after Disney made a statement about House Bill 1557. He repeatedly and publicly stated that he was fighting back for Disney's criticism of House Bill 1557, including at the bill signing ceremony. Key legislators publicly acknowledged that Senate Bill 4C targeted Disney. The law's passage was highly irregular. The bill was added to a special session, convened for other purposes, even though there was no emergency that would justify such rushed treatment. RCID had existed for decades, and Senate Bill 4C did not propose dissolution until June of 2023. The bill passed only 3 days after identical bills were simultaneously introduced in the House and Senate. There was no debate. Stakeholders did not have time to conduct their analysis, and no concrete plan to effectuate the dissolution of the RCID or address the consequences of doing so was proposed in the months following the legislation's hasty enactment. The circumstances surrounding the passage of House Bill 9B reveal the same retaliatory targeting. Again, a special session was convened and the legislature passed the bill within days of its introduction. During the Senate's floor session, Senator Doug Broxson confirmed that the bill was punishment for Disney failing to be apolitical. Senator Broxson said, "We joined with the governor in saying it was Disney's decision to go from an apolitical, safe 25,000 acres and try to be involved in public policy. We're saying you have changed the terms of our agreement, and therefore we will put some authority around what you do." Governor DeSantis, in a recent article, gave the following context for Bill 9B. When corporations try to use their economic power to advance a woke agenda, they become political and not merely economic actors. Leaders must stand up and fight back when big corporations make the mistake, as Disney did, of using their economic might to advance a political agenda. There are no rational bases for either Senate Bill 4C or House Bill 9B, and the purported justifications for both are pretextual. Because both pieces of legislation retaliate against Disney, Disney is entitled to a declaratory judgment that the laws are unconstitutional and an order enjoining defendants from enforcing them. And so before I make any further comments, the prayer for relief is what they're going to be asking for. So they're asking for the legislative declaration to be declared unlawful. They're asking that to be done for all the reasons: Contracts Clause, Takings Clause, Due Process Clause, and First Amendment. They're asking the court to declare that the contracts are in effect and enforceable, and that the Senate Bill 4C and House Bill 9B are unlawful, and orders enjoining enforcement of those laws, plus attorneys' fees and costs and any other relief the court deems just and proper. And that's submitted by a team of attorneys here that all did a very good job. Obviously give yourselves a pat on the back for that one. Jeez, that's a heck of a complaint. So yeah, that's the neatest, tightest, most buttoned, well-prepared complaint that I think I've seen ever. There are just some that are just well put together, and obviously Disney has been waiting for this moment for a long time. They knew something was wrong over a year ago when the initial version of the Don't Say Gay bill was released. And of course, that was just for like pre-K through third grade or something. And then, of course, it got expanded to all the way up through 12th grade. So now you're not allowed to talk about being gay if if you're a teacher and is outside of approved curriculum, which it's not, then you can't talk about it. So yeah, you just can't talk about anything to do with anything other than being straight in Florida on this thing. So they speak out about it, and then the government punishes them. And that's exactly what the First Amendment is designed to protect, that you're not allowed to retaliate against your citizenry, your constituency, for disagreeing with you. We have a long and colorful history of mocking our government, mostly because, as you see, the government deserves to be mocked. The hypocrisy is just dripping from these actions, from the political party. The conservative political party is the party of small government, the party of not getting involved in corporations' lives, the party of not regulating things, as you've seen from East Palestine. But here they are, regulating out the wazoo to try and damage Disney in any way whatsoever. Why not direct your energy towards governing? Could you imagine? We could all be happy together. It doesn't have to be where you're happy and everybody else is unhappy. Like, we can all together be the United States. The united we stand. I don't know. I don't know what happened. I don't go through life trying to be divisive. I don't know why some people do. Anyway, that's a really long one, so I bet you want to go. Let me know what you think of that one in the comments below, and I'll see you there. Love you all.